It is now in order to consider Amendment Number 8, printed in Part A of House Report 112-111. For what purpose does the gentlewoman from California seek recognition?
Mr. Chairman, I have an amendment at the desk.
Amendment number 8, printed in Part A of House Report number 112-111, offered by Mrs. Capps of California.
Pursuant to House Resolution 316, the gentlewoman from California, Mrs. Capps, and a member opposed will each control 5 minutes of this debate. The chair now recognizes the gentlewoman from California.
And I yield myself such time as I may consume.
Gentlelady is recognized.
Mr. Chairman, this amendment that I'm offering with Representatives Carney and Castor addresses one of several concerns we have about this bill. Its harmful impact on state programs that today are working to issue permits while protecting local air quality. Last month, the Energy and Power Subcommittee heard testimony from officials of the states of Delaware and California. Both expressed serious concerns about the impact of this bill on local air quality. The Delaware Department of Natural Resources has this to say about the legislation, and I quote, "The constraints placed on states' rights and authorities will adversely affect our state's ability to protect public health and welfare from the harmful effects of air pollution," unquote. The California Air Resources Board also testified that this measure, and again this is a quote, could have far-reaching unintended consequences on public health. California and its local air districts in some cases require emission controls that go beyond federal law, and that is to address our unique pollution problems. For example, emissions from commercial harbor craft and ocean-going vessels represent the largest source of smog-forming air pollution in the entire Santa Barbara County. These emissions account for over 40% of our local air pollution. In response, the California Air Resources Board adopted rules to help coastal areas like California come into attainment with ozone and particulate matter air quality standards. But HR 2021 would nullify some of these state requirements, and it would increase pollution by preventing our local air quality district from incorporating them into their air permits for offshore drilling production and processing. It's very critical to our local air quality and to public health that emissions from these marine vessels and offshore drilling are subject to common sense regulations, and that is why this simple amendment is before us today. It says that if a state with delegated authority wants to enact more stringent air quality protections for offshore drilling, it can continue to do so. Mr. Chairman, this is about giving flexibility to our local air quality districts so that they can apply the technologies that work best for them. They've been doing so for 20 years. So they can continue their work protecting our air quality and the health of our communities. It says, this amendment, that a one-size-fits-all approach that comes from Washington politicians and giant multinational oil companies is the wrong approach. I urge my colleagues to support this straightforward amendment. It's common sense. It will allow state and local air districts to continue to do their job to protect the air quality of coastal communities like the Central Coast of California. Nothing more and nothing less. I reserve the balance of my time.
The gentlewoman reserves the balance of her time. For what purpose does the gentleman from Colorado rise?
I seek recognition in opposition.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I thank the gentlelady from California for being a part of this debate today. You know, we had, I believe, this amendment or similar amendment in committee. We discussed this amendment. I think, as I mentioned, we've had 2 separate committee hearings on this particular piece of legislation. We had a markup where a number of amendments were offered. A tremendous amount of debate took place, and I believe debate took place on this very amendment. One of the concerns I have with this amendment is the practical impact it would have in what could best be described as a balkanization in the regulation of federal waters, creating a patchwork quilt, so to speak, of regulations as it applies to the federal areas and the OCS. The amendment allowing states to promulgate any regulation for the OCS as long as it can be deemed no less stringent. This will result in chaotic regulation of federal waters, many of which may conflict with interstate commerce. But perhaps even more important is the dramatic expansion of state jurisdiction that this amendment would have. And this was also an issue that was discussed back and forth during the committee, during our markup, at the subcommittee level, at the full committee level, whether or not this would create challenges for the expansion of state jurisdiction. The current law only allows for the delegation of the exact authorities of the administrator. The exact authorities of the administrator, and not the flexibility to create the state's own laws to implement the act. I think that's one of the distinctions that we have sort of walked over during this debate. It's also important to recognize that the federal OCS is different from onshore state borders, where the states do have this type of flexibility in setting their state implementation plans. We talked in committee once again about the Submerged Lands Act and Outer Continental Shelf Lands Act. They were enacted for this very reason, to federalize and provide harmony in the offshore. So state regulations of the OCS will be used, I believe, unfortunately, by those who would try to obstruct and stop domestic energy production. The policy of this bill, of the Jobs and Energy Permitting Act, is to provide a clear process so that resources can be explored. And I'm afraid this amendment would cause the opposite. The Jobs and Energy Permitting Act is a bill that was brought forward because of significant delay in a bureaucratic process through an environmental appeals board that was not created by Congress, but was created as an administrative construct, something that was designed to I'm sure with good intentions, but unfortunately in its applicability, in the way it is working, the way people have used it, is now being part of a great delay. In the time that it has taken for the EAB to work on this bill, 5 years, in the time that it has taken to work on this bill, the company that has the lease in the Beaufort-Chukchi Sea area right now has drilled 400 wells around the world. Not in the United States, not creating U.S. jobs here, not creating U.S. energy, but working abroad. And if we are going to set this country on a path toward energy security, I've said it before and will continue to say it, if we are going to set this country on a path to energy security, then we have to recognize the national importance of allowing exploration to occur. Exploration permits, activities that will take 30 to 45 days. I will yield.
I would like to make one additional comment. I think you have a very good point on the balkanization. We have these federal waters, these outer continental shelf. We have a lot of oil reserves, and we're trying to explore, trying to produce more oil. And if this amendment is adopted, different states can have different rules, so that would complicate things. And we already have a situation where we have different agencies of the federal government issuing these permits. In some areas, we have the Department of Interior. In other areas, we have EPA. If you take that on top of the balkanization, it's going to take a lot longer than 5 years. We may never get a permit, and I thank the gentleman for yielding.
Thank you, the gentleman from Kentucky. And it's frustrating, too, because we continue to hear statements from the administration, from others who wish to pursue a vibrant energy policy for our country, that they, too, agree that we need expanded resource development in the United States, expanded U.S. energy opportunities. But it's almost like lip syncing. They are talking about it, but actually not doing it. And unfortunately, what we are seeing is conversations by the administration without the action to back up that conversation. And I yield back my time.
Gentleman's time has expired. Gentleman from California.
Mr. Chairman, I yield myself 30 seconds to respond to my colleague from Colorado, the author of the bill. Section 328 of the Clean Air Act is what is at issue here today in this amendment. It was created more than 20 years ago, largely at the insistence of California officials. In fact, my Republican predecessor, Congressman Lago-Marcino, introduced this legislation because residents were unhappy about uncontrolled air pollution from offshore drilling, as well as local industry and business groups who were upset that offshore sources were basically free to pollute, while onshore sources bore the burden of heavier regulation to try to make up for the degraded air quality. Only 2 states now have this permission to
Will the gentlelady
yield
yield?
this. And I will,
Gentlelady's time has expired.
I will now yield 1.5 minutes to my colleague from Delaware to speak. Carney.
Gentlelady has 1.5 minutes remaining. The gentleman is recognized.
Mr. Chair, I rise in support of this amendment, and I ask unanimous consent that this letter from the Delaware Department of Natural Resources be submitted for the record.
Without objection, so ordered.
While I oppose the underlying bill, I will only speak to this amendment. It addresses what I think is a nonpartisan issue, and frankly, it appeals to states' rights, which my Republican friends typically support. Delaware is in non-attainment with federal clean air standards, mainly due to emissions that come from outside our state borders. In order to comply with federal law and protect public health, Delaware has the ability to implement pollution control strategies beyond EPA's requirements. Last year, Delaware was given Clean Air Act authority for the outer continental shelf, meaning that the state, rather than EPA, regulates emissions there. Delegated authority is working. The one OCS permit requested of Delaware was granted within weeks, not months. Disputes go through a quick administrative review rather than costly litigation. It does not mean a delay, as my Republican colleague alleged. In fact, this delegated authority is working so well that other states are actively looking into it. Maryland, Virginia, and Alaska have each asked Delaware for its documents on delegated authority. A one-size-fits-all approach like H.R. 2021 is not in the best interest of our states. Our amendment simply preserves delegated authority to the states that want it, enabling our states to oversee pollution control as they see fit. This is not balkanization. It's common sense. I urge my colleagues to preserve states' rights. Supporting this amendment. Thank you. I yield back.
All time having expired in this debate, the question occurs on the adoption of the amendment offered by the gentlewoman from California. All those in favor will say aye. All those opposed, no. In the opinion of the chair, the noes have it.
Mr. Chairman, I ask for a recorded vote on this amendment.
Pursuant to Clause 6 of Rule 18, the further proceedings on the amendment offered by the gentlewoman from California will be postponed.